Hello everyone, Gigi Santoro, Santoro & Sons Real Estate Group, and today I have with me Rob Cohen of Cohen Law, over 18 years of experience, and he's going to talk to us today about probate. I think you should try as best as you can to avoid probate. I want to have this guy who knows everything about it explain to us what probate is, so let's go, Rob.
Well, you forgot the most important word.
What?
The ever fascinating world of probate.
Probate?
No? Okay. Probate is basically a court-supervised process by which the assets of a decedent are marshaled and inventoried, creditors are paid, and beneficiaries receive the assets at distribution. But it's court-supervised. And in Los Angeles County, that means it takes between 12 to 18 months for the process to take place. And it's expensive because the way the attorneys get paid and the person who's in charge of administering the estate gets paid, they get paid based on the value of the assets in the estate, and they get paid out of the assets of the estate. So it's a lengthy process. So let me ask you a question
already. I already have a question.
Yes.
So let's say that the person passes away and they have $1 million in real estate and $1 million in investments.
Okay.
And now you would come in and you would take all the assets together and then you would send them off to a probate referee or whatever it is, or how do we involve a probate referee? Is that just for real estate side and not for the asset side?
Right. The probate referee is assigned by the court to appraise the value of the assets of the estate that are non-cash assets. So real estate investments would be appraised because the purpose is to determine what the value was as of the date of death. Now, when we talk about what assets require probating, we're talking about assets that were in the individual decedent's name at the time he or she passed away and did not have a right of survivorship to it or a beneficiary designation to it. So any assets that are owned, such as joint tenancy assets with right of survivorship, when the decedent passes away, those assets are not included in the probate estate and do not need to go to court for anything.
Because those assets have a direction.
Correct. Automatically, by operation of law, joint tenancy assets that have right of survivorship automatically go to the survivor.
Right.
Same with life insurance or investments, 401ks, IRAs that have beneficiaries designated by operation of law and the instruction in the designation. The beneficiaries automatically, provided they comply with the terms that the plan administrator requires, will receive the assets. It does not require a probate administration.
And you and the probate referee in the court basically get no percentage of that.
Has nothing to do with us.
Okay.
We deal with the assets that were in the individual's name solely, not in a trust, not already in a survivorship situation, or had a beneficiary designated.
Okay. Is there any advantage to have a probate?
Yes.
I mean, what could it be?
It's a public proceeding. So the benefit of a probate, and this is something that we've thought about for a while, because when you have a trust, it doesn't go into court. You frequently will have bickering and fighting, and there's really no oversight of what the trustee is doing unless somebody goes into court and requests that oversight. With respect to a probate proceeding, it's public. Everything has to be approved by the court, and once the court approves a petition for final distribution and says that everything that the administrator of the estate did was appropriate, once that order is signed and the administrator is discharged, there's no ability to go back and claim the administrator violated any duties, a fiduciary duties or anything like that. The other thing is it addresses creditors and it creates a statute of limitations for creditors to make claims. Now when you file a probate, as part of the process you have to identify and notify creditors that there's a pending probate and give the creditors an opportunity to make a claim. That notification creates a 4-month statute of limitations for a creditor. And if the creditor does not submit a claim within that 4-month period of time, they're barred. Period. There's no ability to come back later. With respect to a trust, yes, if there is no probate, there's a 1-year statute of limitations to bring a claim against a decedent. However, if there is no probate administration, a creditor could file a petition to open a probate on their own for the purpose of asserting a claim, and that 1-year statute of limitations doesn't have any impact. Once the probate is started and the notification to creditors is submitted through the probate process, that's where the important statute of limitations comes up. So there are benefits to it.
All right, let's talk a little bit about that, because I did run into a situation where there was some very dissatisfied family members with regard to the person who passed away and then the whole drama that went along with it.
Right.
And they were saying they had been paying for some of their mom's care in the assumption that they would have reimbursement upon her death. And so do those people consider themselves creditors as well?
Yes.
Okay.
Yeah,
So
they,
they have
they
to-
should have, they would have the basis to file a creditor's claim. If the expenses were for their parents' care, maybe they advanced costs, or they paid for prescriptions and caretakers, things like that, yes, they would be a creditor of the estate. And they would have a right to submit a creditor's claim for reimbursement,
Up to 4 months, and that's it.
assuming that there's a probate administration that's opened.
Yeah.
If there's no probate administration, they have a year from the date of death to submit the claim, basically
Okay.
file a complaint. But if they're, let's say that the administration through a trust, or there's no probate, takes longer than a year, and maybe the beneficiary who's got the claim is dissatisfied, but a year has passed, they could open a probate for the purpose of asserting their claim. Now, there's a lot of different issues about whether a beneficiary can assert a claim as a creditor. Some estate plans indicate that that might be a contest of a trust if you were to assert a claim as a creditor.
Right.
But without those types of specific issues, that's the right process.
Okay, I have one final question. So in the idea of you have your probate, but isn't there a way to do exactly what you're talking about in a trust?
Yes,
Okay, you would be able to have directives for every single scenario and situation?
right.
Okay.
So the idea of avoiding probate through the establishment of a trust is all of the assets of the individual are transferred to the trustee of the trust. That means that when that individual passes away, he or she has no assets in his or her own name that would require a probate administration.
Okay. Wow.
That's how you avoid the probate by creating a trust.
Amazing information. Come on, you have to love this. All right, please give Rob Cohen a call. His phone number is right down here, and you know who to call when you need real estate help, because look at who I have in my arsenal of people to help us, okay? So give me a call, Gigi Santoro, Santoro & Sons Real Estate Group. Have a great week.